I think we may start our conference with the opening speech. So, dear professors, dear students, and dear guests, and dear all, I would like to welcome you all in the name of the Department of European Union Law of the Ankara University Law Faculty, Ankara University European Union Research Center, and Jean Monnet Chair project titled Legal Issues in European Union-Turkey Relations. I would like to introduce these three organizers very briefly. First of all, Ankara University could be described as one of the leading universities in EU studies in general and EU legal studies in particular in Turkey. In this regard, it is among a few other universities to have an EU law department at its law faculty, which was established in 2003. Secondly, Ankara University European Union Research Center was established in 1987 in a year when Turkey applied for European Union membership. Since then, in order to contribute to Turkey's European Union membership process, in the EU Research Center, we have been organizing certificate programs, making research, publishing works, and organizing cultural and scientific events in relation to the European Union. Lastly, within the framework of the activities of Jean Monnet Chair, we have mainly three activities besides teaching, of course. For students, we organize every year a summer school titled European Union and Turkey-European Union Relations in Turkish. This is free of charge and with a certificate. The next one will be in June, July this year. Next, for young researchers and academics dealing with EU studies, we organize each year one-day national conferences titled European Union Law and Legal Dimension of Turkey-European Union Relations, in Turkish again. The next one will be in May this year. Lastly, for those interested in EU studies in general, we organize, as of today, international conferences titled Legal Issues in Turkey-European Union Relations. This is our second conference in this regard. Today's conference will have two sessions. The first one, which will be moderated by me, is devoted to migration-related issues in Turkey-EU relations, and the second one, which will be moderated by my colleague Gülüm Hoca, is devoted to trade-related issues in Turkey-EU relations. Lastly, there will be closing remarks by a delegate from Republic of Turkey, Ministry of Foreign Affairs, and Directorate for EU Affairs. Unfortunately, though it was written in our poster, due to their busy agenda, a representative from Delegation of European Union to Turkey will not be able to participate in today's conference. Let me thank to all our panelists and delegates for being a part of this conference. We are very honored to have them with us. A last note for participants, this meeting is being recorded, I think already told you by Zoom, and by joining, we assume that you are giving consent to this meeting as being recorded. So I wish all of you a pleasant conference. And now I want to continue with our first session on migration-related issues in Turkey-EU relations. Now I changed my title as the moderator, and I want to give some information on our first session. We will follow the order in our poster, and I would like to kindly ask our panelists to have their presentations in 15 minutes in order to have a 13-minute for questions and answers session. For the participants, they can post their questions to the relevant area, I mean the QA part in the bottom and middle of your screen. I think it should be there, a QA letters. You can put your questions there anytime. This means without waiting for the QA session to start. We will collect the questions during the speeches. Now, firstly, I would like to give the floor to Professor Thomas GIEGERICH, who is the director of Europa Institute of Saarland University. We are incredibly happy to have him with us today, especially since our two research assistants were visiting researchers at Europa Institute of Saarland University in the past. His paper title is The Common but Differentiated Responsibilities of Turkey and the EU in Relation to Migration. Professor GIEGERICH, the floor is yours.
Thank you very much. Thank you for your invitation. And the first thing I will try to do is share my screen. I hope it works. Let's see. Can you see it? Perfect. Now, I will speak about, as Professor GÖÇMEN already said, the common but differentiated responsibilities of Turkey and the EU in relation to irregular migration. This is my outline. In the first paragraph, I will explain the principle of common but differentiated responsibilities. In my second paragraph, I will briefly sketch the rule book on irregular migration, consisting of hard law obligations of the EU, member states, and Turkey, as well as soft law obligations of all three. The third paragraph is devoted to identifying common but differentiated responsibility elements in the EU-Turkey Migration Management Partnership. This is my term. And in the fourth paragraph, I will venture a brief look into the future. Where is the EU-Turkey Migration Management Partnership heading? The common but differentiated responsibilities is a principle that plays a key role in international environmental law. It denotes the move away from the formal equality of states. It has the following characteristics. A common goal of humanity is pursued, in this context, the clean environment. There is a global partnership regarding the attainment of that goal. There is an ensuing duty of the partners to cooperate. There is a burden and responsibility sharing of all partners, but the partners have different obligations. The differentiation with regard to obligations is based on considerations of equity, with two components. Firstly, a responsibility component, according to the polluter pays principle, more or less, which says that those states that are more responsible for the environmental degradation of the past do have to do more to clean up. And then there is a capabilities component, according to which every state contributes according to their abilities. The differentiation seeks to attain sustainable development. The differentiation goes along with a transfer of financial means and capacity building to enhance the capabilities of the developing countries. The principle is legally binding when included in treaties such as the UN Framework Convention on Climate Change and the Paris Agreement. Otherwise, it is part of soft law. That means that the principle is characterized by a mix of legal and political obligations. And the principle of common but differentiated responsibilities is inherently an altruistic principle. Now, my question for today is, what role does that principle play in the relationship between Turkey and the EU, including the member states, regarding the management of irregular migration? That, of course, depends on the applicable hard law and soft law rules in the Turkey-EU relationship as regards irregular migration. And that brings me to my second paragraph, the sketch of the rule book on irregular migration. I start with a hard law component. There is, of course, primarily the convention relating to the status of refugees, the Geneva Convention of 1951, that binds Turkey and all EU member states, but not the EU as such. The protocol relating to the status of refugees of 1967, the Geneva Protocol, that also binds Turkey and all the member states, but not the EU as such. And then, of course, the Convention for the Protection of Human Rights and Fundamental Freedoms, the European Convention, that again binds Turkey and all the member states, but not the EU as such. Under Article 78 of the Treaty on European Union and Article 18 of the Charter of Fundamental Rights, the obligations of the Geneva Convention and Protocol are transposed into primary EU law, which makes them binding on all member states and the EU. And the Charter of Fundamental Rights of the EU transposes the European Convention into primary EU law, making it practically binding on all member states and the EU. And the last hard law component is the EU-Turkey readmission agreement of 2013. That brings me to the soft law components. Primarily the Global Compact on Refugees that was affirmed by the UN General Assembly in 2018, and the EU-Turkey Statement of March 2016. Let's identify more specifically the hard law obligations of the EU, the member states, and Turkey deriving from that rulebook. There is a very general duty to cooperate with regard to refugee problems in order to ease the burden for the host countries that can be derived from the Geneva Convention read together with relevant articles of the UN Charter, but it is very general. Then, of course, there is the very specific non-refoulement principle under Article 33 of the Geneva Convention, Article 3 of the European Convention on Human Rights, and Article 78 TEU, as well as the Charter of Fundamental Rights, which says that there must be no return of any person to territories where they face a real risk of being persecuted or subject to torture or inhuman or degrading treatment. There must be an effective remedy against removal in violation of the European Convention or the Charter of Fundamental Rights. And there is an obligation of readmission of own nationals as well as third state nationals and stateless persons who illegally and directly entered the territory of one party from the other party under the EU-Turkey readmission agreement. Turning to the soft law obligations, first those deriving from the Global Compact. International solidarity and cooperation regarding the predicament of refugees as a common concern of humankind. A more equitable and predictable burden and responsibility sharing with the host countries. Joint efforts to tackle the root causes of large refugee situations, a participation in resettlement efforts in third countries, and the inclusion of the relevant civil society stakeholders in migration management so as to make that management more effective. What soft law obligations can be derived from the EU-Turkey Statement of 2016? Turkey will take back all new irregular migrants crossing from Turkey into the Greek islands. For every Syrian so returned, another Syrian will be resettled from Turkey to the EU. Turkey will prevent new sea and land routes for illegal migration opening between Turkey and the EU. A voluntary humanitarian admission scheme will be activated by the member states once irregular crossings have been ended or permanently reduced. The EU will pay 6 billion euros for refugee projects in Turkey. There will be a joint endeavor to improve the humanitarian conditions inside Syria. The visa liberalization for Turkish citizens will be accelerated by the EU, subject to the fulfillment of the benchmarks. Work on upgrading of the customs union will continue, and the process of Turkish accession to the EU will be re-energized. But, and that's the big but, the human rights of irregular migrants are utterly neglected in that whole statement, neglected by all participants, by the EU, by the member states, and by Turkey even though these are hard law obligations. Now I would like to identify the common but differentiated responsibility elements in the EU-Turkey Migration Management Partnership. It pursues the common goal of humanity, solving the humanitarian crisis due to irregular mass migration on the regional level. There's practically a regional partnership regarding the attainment of that goal. The global compact is transposed into a regional arrangement. The ensuing duty of the EU and Turkey to cooperate are accepted by both partners, and different obligations of the partners are also accepted by both of them. Turkey hosts most irregular migrants from Syria, almost 4 million of them, while the EU supports Turkey financially, less with regard to capacity building concerning the local integration of migrants in Turkey. That differentiation is based on considerations of equity. There is no responsibility component in difference to the common but differentiated responsibilities principle in international environmental law, because I think there is no responsibility of either the EU or Turkey for the root causes of irregular migration. But I put a question mark there, we might discuss it. Certainly there is a capabilities component. Turkey, as the host state, is geographically and culturally closer to Syria than the EU, while the EU is financially stronger and more experienced with regard to local integration of migrants than Turkey. The differentiation is hardly related to sustainable development, but there is a mix of legal and political obligations of the EU, the member states and Turkey concerning irregular migration. On the other hand, we do have a special legal and political relationship between the EU and member states of the one part and Turkey of the other part that intersects with the Management Migration Partnership. It's based on the Association Agreement and Additional Protocol, of course. It's based on Turkey's application for EU membership and the fact that the accession negotiations started a long time ago but remain suspended. Both the EU and Turkey used bargaining chips concerning that special relationship to reach the compromise in the EU-Turkey statement. The burden sharing in the special EU-Turkey relationship is more egoistic than envisaged by the common but differentiated responsibility principle in general. The basis of the EU-Turkey Migration Management Partnership are less shared values or convergence than mutual interests. Let's have a brief look into the future. Where is that EU-Turkey Migration Management Partnership heading? Well, the crisis in Syria continues, as you all know. New crises in Afghanistan and now also Ukraine have come up. There is no prospect of quick repatriation of the irregular migrants. The number of irregular migrants heading towards the EU is rather likely to increase. It seems that a recalibration of the burden and responsibility sharing between the EU and Turkey is required. That could be an increase of financial support to Turkey by the EU. There could be more EU engagement in capacity building concerning integration of migrants in Turkey. There could be more resettlements of irregular migrants from Turkey to the EU member states, and more joint efforts to tackle the root causes of irregular migration. More joint efforts perhaps to open regular migration routes. The problem is that we do not have any consensus within the EU on solidarity and burden sharing regarding irregular migration, despite legal obligations imposed by primary and secondary law in that regard. There is no hard law obligation of the EU and member states to extend burden sharing by admitting irregular migrants from Turkey for resettlement. On the other hand, there is no hard law obligation of Turkey either to prevent irregular migrants from heading for the EU and applying for asylum in orderly manner. It seems that a soft law agreement on further burden sharing will enable a compromise on the basis of the common but differentiated responsibility principle and the special relationship between the EU and Turkey and the balancing of their interests. The EU-Turkey statement is indeed part of the EU Commission proposal of 2020 to overhaul the common European asylum system. That indicates that the EU strategy of externalization of protection responsibility by preventing arrivals of irregular migrants in the EU will continue. Thank you very much.
Thank you very much, Professor GIEGERICH. That was a wonderful presentation. I do not want to take much time as the moderator, so I will continue with our second speaker, second panelist. Now I want to give the floor to Associate Professor Gözde, who is one of the most productive EU academics in Turkey and works at Dokuz Eylül University Business Administration Faculty. Her paper title is An Analysis of the EU's New Pact on Migration and Asylum and its Possible Impacts on Turkey. So Gözde Hocam, the floor is yours.
Thank you so much, İlke Hocam. Thank you so much for hosting me in the first place, İlke Hocam, and also giving me the opportunity to address the audience here today. Hopefully, I'm also nervous in terms of whether or not I'll be successfully uploading my presentation. So let me try it in the first place. It might take some minutes. Okay, hopefully you see my presentation.
Now we see it, Gözde Hocam.
Okay. So, today I'm going to talk about the European Union's impact on migration and asylum, which was accepted in the year 2020. I'll also try to make an analysis in terms of its implications on Turkey-EU relationship. Also, I reformulated my presentation and added the last parts through which I'd like to briefly mention the current mass influx fleeing from Ukraine to Eastern European countries. As is known, the foundations of a system which allocates asylum-related responsibilities among the member states date back to the 1990 Dublin Convention and the following Dublin regulations. Dublin system has been the core part of the common European asylum system. However, Syrian refugee crisis, which has led a huge number of asylum seekers rushing into the European Union territory, revealed the need for the reform of the common asylum system. And hence, the European Commission introduced Dublin IV regulation proposal in May 2016. However, the negotiations in the Council bore no fruit due to the strong resistances of some member states, particularly Hungary and Poland, against the obligatory solidarity mechanism that was introduced by the proposal. Since the member states could not reach any compromise, the process resulted with the withdrawal of the proposal. The ongoing deadlock forced the European Commission to come up this time with a new legal instrument under the name EU Pact on Migration and Asylum in 2020. The new pact is accompanied by 5 new legislative proposals. Among these legal instruments, what is significant for us is the proposal for a new regulation on asylum and migration management. And I will also focus on its relevant provisions in terms of solidarity. The new pact introduces an integrated approach for bringing policies together in the fields of migration, asylum, integration, and border management. When the major novelties introduced by the REM are listed, one may consider the extension of the family concept, the cessation of the first entry responsibilities after 3 years, the acquirement of EU long-term residence status only after 3 years as the most positive developments. Since this subject is indeed highly technical, my slides might seem to you a bit comprehensive, but I'll try to summarize them. The new pact and the REM introduce a mandatory but flexible solidarity mechanism for the member states. Yet the member states are under the obligation to share their responsibilities, as Professor GIEGERICH has already pointed out, on a fairer basis, including its financial outcomes. Under the REM, the member states are granted with a variety of options, which range from relocation of asylum applications to providing return sponsorships or providing capacity building measures. And these contributions are determined to be in line with a distribution key, which is calculated on the basis of the member states' GDPs as well as their populations. And sorry. Okay. Yes, here. Concerning the procedures when providing solidarity contributions, these procedures are indeed ultra bureaucratic and highly complicated. Solidarity contributions might be initiated following research and rescue operations and migration pressure. Member states, in the first place, prepare their solidarity response plans, indicating what kind of contributions they intend to make. And the system is then supported within a correction mechanism, which the Commission may trigger in cases of necessity. Yet the Commission may also decide on some readjustments to be made by the member states. To elaborate with regard to the scope of these solidarity contributions, very briefly, in terms of a relocation procedure, the benefiting member states should ensure that the applicants do not pose any danger to national security and public order to the member state of relocation. In terms of return sponsorship procedure, the measures to be taken by the sponsoring member state might be in the form of assisting voluntary return, supporting policy dialogue with the third countries in terms of readmission, ensuring the delivery of travel documents, or organizing scheduled flights. Under the capacity building measures, the member states could provide measures to strengthen the capacity of the member states in terms of asylum, reception, and return policies, but these are to be criticized since they are vaguely defined in the literature. And when we examine the critics brought to the Pact and the REM, the Pact is primarily criticized in terms of the process through which it has been created. Both the European Council and the Ministers of Interior are said to be given a large level of discretion, and that is likely to lead the process to a reverse Europeanization or intergovernmentalism in terms of policy areas, which indeed the community method of cooperation was implemented since Lisbon Treaty. So that is indeed a step backwards in terms of integration. Hence, the critics also note that the Pact is hardly to be read as an agreement to reconcile different views, but rather a compromise to allow positive views. And secondly, the Pact and the RAM are criticized for bringing forward an integrated approach for different policy areas which have originally different scope and objectives. The links between asylum, protection of human rights are artificially established, yet the integration of these areas in one legal instrument may cause legal incoherence. And one of the most significant criticisms is that these two instruments still preserve the criterion of the first irregular entry. As is known, this is one of the most criticized criteria of the Dublin system, since it puts the frontline countries under a disproportionate burden. The European Parliament and several NGOs have been advocating for the removal of this criterion. But on the contrary, these instruments seem to increase the already existing administrative bureaucracy, the costs, infrastructural effort, which are imposed on the frontline countries. The preservation of this criterion also means that the asylum seekers are still not granted the right to make their own choices of settlements, which is hardly to be compatible with the basic standards of human rights protection. Another criticism concerns the flexible solidarity mechanism. The member states are granted with a large level of discretion for choosing between solidarity contributions that would fit best with their nation-state interests. Hence, this might grant the member states the ability to refrain from mandatory relocation, deriving from their international protection responsibilities. And particularly, the return sponsorship might become more attractive to the member states in comparison to providing relocations. Hence, that there is a risk that the number of contributions through returns might disproportionately remain higher than the actual need, which is, of course, obviously to the detriment of the member state under pressure. Last but not least, no solid sanctions or enforcement tools seem to be proposed in cases where a member state would fail to comply with the solidarity mechanism. The Commission's reliance on the infringement procedure might be too long and might remain insufficient in terms of forcing a full enforcement. There are several other critics which might further be brought to the Pact and the RAM, but due to limited time, I'd leave them to questions part and skip to mentioning briefly the implications of the Pact on Turkey. The Pact has been referred to by many as the old wine in new bottles. And it's seen that the same logic applies to the cooperation mechanism, which the Pact introduces for the EU in terms of its relationship with its neighboring countries, including Turkey. The Pact makes a reference to Turkey under Section 6, titled Working with Our International Partners. And one of the most significant proposals of the Pact, which also concerns EU's relationship with Turkey, is the mechanism of the return sponsorship. This mechanism intends to increase the number of returns of asylum seekers from the EU to either transit countries or to countries of origin. In that sense, the Pact reintroduces readmission agreements as a significant policy tool under the EU's external dimension and the visa liberalization in return. Hence, the Pact urges the EU to improve its cooperation with its neighboring countries and to continue concluding readmission agreements. In terms of the Pact's implications on Turkey, the Pact is hardly likely to offer a fresh instrument or a new mechanism than the existing ones, which have already been exercised within the sides' relationship. As is known, EU-Turkey readmission agreement, Greece-Turkey readmission agreement, and the 2016 statement, which Professor GIEGERICH has already mentioned, already provide the basis for the return of Syrian refugee nationals from Greece on the basis of 1-for-1 resettlement scheme. The Commission's May 2021 report notes that between April 2016 and February 2025, almost 28,000 Syrian nationals were resettled from Turkey to the EU. And again, since 2016, a total number of 2,000, almost roughly speaking, 2,000 irregular asylum seekers are reported to be returned from Greek islands to Turkey. Last year, both the EU and Turkey sides delivered their intentions to revise or renew the 2016 statement. The statement significantly contributed to the sharp reduction of irregular asylum seekers passing from Turkey to Greece. In return, almost 4 billion euros out of a 6 billion, as Professor GIEGERICH had pointed out, had been dispersed by the EU to Turkey. Though this financial assistance is significant, the EU needs to invoke more concrete steps and introduce more effective instruments for assisting both Turkey and the borderline countries like Greece. It should rather introduce binding rules instead of a voluntary mechanism as introduced under the Pact. Otherwise, there will be no real solidarity between these countries as long as some member states continue shifting their responsibilities rather than sharing. EU-Turkey statement is intended to cover a temporary and extraordinary situation, but the recent experiences in Ukraine have revealed that mass migration is unlikely to remain as a temporary issue for the foreseeable future, which demonstrates that more permanent solutions and mechanisms need to be established on a cooperative basis for tackling these issues. And this has already been acknowledged on several occasions by the UNHCR. On the other hand, unfortunately, in terms of the visa liberalization process, which was also subjected to Turkey's fulfillment of many additional criteria, still no solid measures have been taken by the EU, nor Turkey's accession process has been re-energized. Yet the Pact does not seem to offer any new incentives for EU-Turkey relationship, any different and effective than what the sides had earlier experienced. Therefore, the EU needs to introduce new, more reliable and sustainable instruments for strengthening Turkey's cooperation in migration management. Lastly, very briefly, I'd like to mention the war in Ukraine. The ongoing conflict led the EU to trigger the Temporary Protection Directive introduced for mass influx situations for the first time ever since its adoption in 2001. The directive will provide the asylum seekers from Ukraine to be protected under a clear status, facilitating their access to certain rights. However, the Council's implementing decision, which activated the directive, does not give the same protection to everyone without any differential treatments, such as international students or persons who had anticipated the invasion and left Ukraine before the 24th of February. They are excluded from the scope of this protection. It certainly might not be easy for the people escaping from war to prove the host countries' authorities that they are eligible for temporary protection. Yet the procedural requirements and documentation process should be minimized when delivering decisions on this protection. And the member states can provide immediate protection for 1 year, which might be extended up to 3 years. This temporary protection shall cover the right to stay and access to a minimum level of social and welfare rights, as well as the right to work and access to education. The implementing decision gives the beneficiaries the right to choose the member states they are willing to stay, which are very positive developments. Currently, all the member states are showing a remarkable degree of solidarity and consensus, which has been very rare and significant. Hopefully all Ukrainian nationals within a short period of time will be able to return safely to their home countries. Otherwise, some member states might again remain under a huge pressure, while others might start resisting again, which might lead to the same deadlock and controversies as had been experienced earlier. And my last words. I hope I didn't exceed my time too much. To conclude, unfortunately, it's seen that both the Pact and the REM preserve the Dublin system's criticized structure and logic. Yet these new instruments seem far from efficiently addressing the deficiencies existing in the system. Particularly, the flexible solidarity mechanism has to be reformulated. The past experiences have revealed that the preservation of the first irregular entry criteria has put a disproportionate burden on the frontline countries and needs to be abolished. The RAM proposal has made it more difficult for asylum seekers to ask for international protection from the EU countries. However, the EU as a normative power is expected to urge its member states to take more responsibilities in terms of their international obligations. Hence, the EU co-legislators should revise these instruments by taking into consideration particularly the critics raised by the European Parliament and the NGOs specialized in the fields. Thank you for listening. I hope you enjoyed.
Thank you, Gözde Hocam, for your remarkable presentation, which also includes the recent issue of Ukraine. Thank you a lot. Now, thirdly, I would like to give the floor to Assistant Professor Melanie FINK, who is my friend and colleague from Leiden University, where I had my postdoc studies. Melanie works still at Europa Institute of Leiden Law School, and her paper is titled as Frontex's Cooperation with Third States, Legal Framework and Access to Justice Challenges. The floor is yours, Melanie.
Thank you so much, Ilke. First order of business, also I will try to share my screen here. Let's see. Does it work? Yeah, wonderful. Okay, yeah, so thanks so much for the invitation, Ilke. It is a pleasure to be here in such wonderful company. I will talk today about the EU agency Frontex, actually called the European Border and Coast Guard Agency now. Probably most of you have at least heard of it. It's been, it made quite an impressive rise since its establishment in 2005. And this went kind of from a very small unknown agency to quite a major player in the EU's border management. So originally Frontex was actually set up to monitor migration flows to the EU, to provide risk analyses, see which borders might be the most vulnerable for inflows of refugees or irregular migrants, and ultimately to help member states in managing those. And its main tool to do that has been to organize so-called joint operations. Those are operations where EU member states basically share resources to be deployed at a specific external border. So for example, Frontex would pull together border guards from the Netherlands, from Germany, vessels from EU countries to be deployed at the Greek external border, for example. When Frontex started out, it didn't have really an international cooperation mandate to speak of, really kind of small provisions set out that it can to some degree, cooperate with relevant authorities also abroad, but it was really very limited. And this has changed a lot since the establishment of Frontex in 2005. So Frontex, its founding regulation, the document under which it was established and what governs its operations and activities, was changed 3 times or overhauled really 3 times. There were some other minor changes along the way. And in each step, Frontex also got an increase in its international cooperation mandate. Now, the main instrument for international cooperation are actually working arrangements. Working arrangements is not an international treaty. It is a soft law instrument entered into between Frontex and the border control authorities of a third state. It signed a working arrangement with Turkey in 2012, or in fact with the Foreign Ministry of Turkey. It also collaborates with Turkey on risk analysis. That's mainly intelligence sharing, actually, and has liaison officers. Now, I will focus on a different form of cooperation, though, and a form of cooperation that is really new to Frontex, and it has not entered into yet with Turkey, but of course might in the future. And that is its operational cooperation. I'll explain in a moment what that means. So as I already mentioned, the main sort of activity that we see Frontex doing, and also what its budget is mainly spent on, is the organization of these joint operations. Now, and what this is traditionally limited to the EU member states. So this happens, of course, at the external border, but always on the territory of a member state. That is the idea of it. And this was expanded through the latest amendment of the Frontex regulation, where Frontex gained the power also to organize joint operations on the territory of a third state. Now, that brings with it, so even though it is Frontex's main activity, let's say, joint operations, it is also the activity that has come under most criticism from a human rights perspective. So what I'm going to do in the following few minutes now, I'll set out the legal framework for this cooperation, and then I'd like to move on to highlight the main challenges from human rights, especially access to justice perspective. Okay, so let's start with the legal framework. Hello, everything went black for a moment. Can you hear me
Yes.
back? This was really odd. I hope it doesn't
you
happen
are now
again.
online again. That's okay, you are online again.
Okay, now let's hope it doesn't happen again, because I have no idea what this glitch was. I'm glad to be back. Now, I just was about to start to explain the legal framework for this type of cooperation. It is quite an intricate setup, in fact. Obviously, the EU treaties apply. The next layer is the Frontex regulation, so the document that establishes and regulates Frontex activities. But then a number of other layers kick in. The first one of these is a status agreement. So if Frontex wants to establish a cooperation within which it can go to third country territory and conduct an operation there, it needs to sign, or it needs the EU to sign a status agreement with that third country that regulates what can be done
Melanie, we can see your mouse and the screen changing, but cannot hear your voice.
Okay. So let's
Now
hope.
you are
Can you hear me back?
again.
I'm so sorry
Yes.
about this. This has
That's
never
okay.
happened. No idea. I just tried to continue. Now, up to date, a number of status agreements have been signed. They focus on the Western Balkans. What I'd like to point out in all of these status agreements foresee that Frontex officers can be sent to the third state territory and this is what I'd like to emphasize, exercise executive powers there. So this is quite an intrusive form of cooperation. And this is provided for in this, or the possibility to do that is provided for in these status agreements. All of these status agreements also contain the possibility, or also contain immunity of these persons from the jurisdiction of the third state. And these status agreements that have been signed with the Western Balkan countries are thought to be also the templates for status agreements to be signed along the same lines with other third states with whom Frontex would like to engage in this type of cooperation. The next layer that comes into play is when an actual operation is launched. There are two operations so far that Frontex has launched, one at Albanian, one in Albania and one in Montenegro. Now, if Frontex indeed wants to launch such a joint operation, it needs to sign, in addition to the status agreement, an operational plan with the authorities of the third state concerned. So that operational plan will then exist for every single operation. And that sets out really like the specifics of the operation, like who has which tasks and responsibilities, what are the command and control arrangements, what instructions, specific instructions to deployed personnel, and I'll emphasize this, how do we ensure fundamental rights compliance and access to justice? I'll come back to this in a moment. And then, of course, the last layer is the implementation of this operational plan, the factual conduct on the ground. Now, I'll move on to point out what I think are the main two challenges when human rights violations occur during these operations. I'll first, probably interesting to have a closer look at what types of human rights violations might occur. It is not so immediately obvious, but in addition to, so what the human rights violations that Frontex has been mainly accused of on EU territory were pushback operations that violate the principle of refoulement. So where a person is sent back to a country where without being able to raise sort of concerns regarding access to asylum or being faced with torture, inhuman or degrading treatment or punishment in the country where they are sent back to. Now, when an operation takes place on third state territory, what comes into play, in addition to other forms of human rights violations that might, of course, occur, is also the right to leave. Since the goal of these operations is basically to not even have persons enter the EU, it has a very different, it targets the other side of the coin than operations that take place on EU territory. And that conflicts with the right of everyone to leave a country. Of course, that's a very imperfect right, because there is then not typically a right to enter another country, but nonetheless, this right exists. So there is a certain tension there. What I would like to highlight, though, are the challenges to accessing procedures to make human rights complaints heard. So less exploring what kinds of human rights violations do occur or might occur, but more, what if an individual does feel like a human rights violation occurred? How do I go about raising that complaint in a formal manner? And there are two main obstacles in this respect. The first is, what do I challenge here? And the second one is, where do I do that? Now, under what, you see here two axes. I have the procedures that exist and the chances to be successful in those. Now, if you remember back the legal framework that I presented initially, in principle, you can pick any of these layers to challenge depending on where you believe that the origin of the human rights violation lies. And each of these routes has specific challenges. Now, if an individual were to go for a challenge of the status agreement, there are procedures for that in EU law, the action for annulment. It's not very accessible to individuals, but let's say it exists. But the status agreements are really general in nature. I briefly explained before what more or less they contain. They are, in other words, not very likely to be the actual source of the human rights violation. Somewhat similar is the operational plan, with an additional challenge because they are a soft law instrument. So the procedure that I was mentioning before, the annulment procedure that exists to challenge legal acts, does not necessarily apply to soft law instruments, or only under very limited circumstances where you can prove that they have legal effect. So that is an extra challenge there. And in addition, also, they are really more operational agreements of the nature that allocate tasks and competences. The third possibility to raise a human rights complaint is, of course, to target the implementation of this entire legal framework. So the specific acts on the ground, that is the most likely to actually be the source of a specific human rights violation. Think of a pushback, think of excessive use of force. That's all not like written down in the operational plan or something. That is a factual measure that takes place on the ground. The problem with that is that we have very few procedures in EU law to claim that something like this violates human rights. It's not an act that can be annulled, typically, so the annulment procedure is not available. That very much leaves individuals with the possibility of lodging an action for damages, which is, I won't go into detail on this, but which is an action that has a really high threshold to be successful. It's basically not really thought of or made as a human rights remedy, but more as a form to recuperate economic loss. What's the conclusion of this? There is a combined effect of these operations when they violate human rights. So all these measures, all these elements of the legal framework have a combined effect that might violate human rights, but it is very difficult to target each individual layer of formal activity that takes place here. I'll be very brief on the second one because I know I just ran out of time, which is the where. Where do I go to challenge, to raise a human rights complaint in this context? Now, this is really, this is something that is a problem already in the EU, but even more so, of course, when you have yet another state come in. And this concerns the fact that there is basically different there is not as, or no, wait, there is different courts that have jurisdiction over each of the involved actors. So to complain about the third state's activity, you have to go to a third state court. Complain about Frontex, you have to go to the Court of Justice. And to complain about a member state involved, you have to go to whatever national court that is. In other words, there is no common forum, which makes it really complicated for individuals that would like to raise a complaint, because they either have to decide beforehand who exactly they think was the source of their of this violation that they would like to raise a complaint against, which can be really tricky to do in these operations, especially when what happens is not very transparent. Or they say they go to all of these, all of the courts, launch parallel proceedings, but that is, of course, insanely costly, not just from a financial perspective, but also human knowledge capital. It's really difficult to find legal support in so many different jurisdictions at the same time. So that brings me to my conclusion. If human rights violations occur during this new type of cooperation with third states that Frontex has, it is typically through the combined effect of several layers of the law. But each measure can only be challenged in isolation. So what we would actually need is procedures to assess this combined effect. And this could be something done in the status agreements, setting up a specific, maybe administrative body that could deal with these types of complaints. Thank you so much. That was it from my part.
Thank you, Melanie, a lot for your revealing presentation. It was very interesting indeed. And now I want to continue with our fourth panelist. I would like to give the floor to Associate Professor Gülüm Bayraktaroğlu Özçelik, who was one of my professors from Ankara University Law Faculty, and with whom we worked together at Department of EU Law at Ankara University Law Faculty. Gülüm Hoca now works at Bilkent University Law Faculty, and her paper is titled as Legal Status and Rights of Syrian Nationals in Turkey. Gülüm Hocam, the floor is yours.
Thank you very much, dear Chair, distinguished colleagues, dear students and guests. First, I would like to take the opportunity to thank Professor GÖÇMEN for his welcoming remarks and for his kind invitation. It is good to be back home, I would say, because I was educated at Ankara University. I've spent more than 10 years working at the university, both in the departments of private international law and in the European Union law. Since 2009, I work at the Department of Private International Law of Bilkent University. At least virtually, nowadays, I'm coming back to Ankara University. Today, my presentation will be on the legal status and rights of the Syrian nationals in Turkey, a topic which we have been discussing and debating from different points in Turkey in the last decade, I would say, because as we all know, the civil war in Syria affected most of the countries, Turkey being, I think, the most affected one, having the longest borders with Syria. So let me share my screen before I forget. Sorry for that. Do you see now?
Yes, Gülüm Hocam, we can see it.
All right, good. although the Syrian civil war affected Turkey in different contexts, due to its geographical location and its cultural bonds, Turkey has traditionally been a country for a country of transit and destination for migrants. It had also previously experienced the mass influx of migrants in different years. Examples include the mass influx of 350,000 migrants from Bulgaria in 1989, around 1 million migrants from Iran in 1979, 500 migrants from Iraq following the Halabja massacre in 1988, around 500,000 migrants from Iraq in 1991 due to the Gulf crisis. So we have experienced similar attempts, we had similar experiences previously. However, such experiences fall far behind the situation in Turkey has faced in the last decade, both in terms of the number of migrants and of the duration of the stay, their stay in Turkey, which varied between a couple of months to 1 year at most. The mass influx of Syrian nationals, coupled with the open door policy of the Turkish government, have made Turkey the country hosting the largest migrant population in the world since 2011. The number of Syrian nationals under temporary protection in Turkey increased from some 14,000 to 3.7 million. This 3.7 million includes only the registered persons, and including the non-registered individuals, it is estimated as around 5 million Syrian nationals, plus some 320,000 persons from other countries. And the status of Syrian nationals have been subject to much comment over the years in the process of transforming them from treating them as guests to temporary protection beneficiaries. As Professor GIEGERICH and Professor Kaya has explained earlier, migration has been an issue of a very important issue dominating EU-Turkey relations in the last decade, at least starting from 2013 with the conclusion of the readmission agreement. Since the previous panelists have explained this aspect, I want to save some time for myself and move to my topic as the status of Syrian nationals. First, I can only make general remarks within the time I will have, but I will be very happy to answer your questions if there is. First, let's start with their status in Turkey according to Turkish law. The law on foreigners and international protection, dated to 2013, is the first asylum law in Turkey, and it provides for international protection and for temporary protection. As Turkey applies the 1951 Geneva Convention on the Status of Refugees with geographical limitation, international protection is provided for 3 groups of persons: for the refugees, for conditional refugees, and for persons under subsidiary protection. Because of the geographical limitation, the refugee status is granted to persons who satisfy the conditions of being accepted as refugees as a result of events occurring in Europe. This geographical limitation also made the Turkish legislator to invent the new term of conditional refugee status for persons who satisfy the conditions of being a refugee, but as a result of events occurring outside European countries. And there exists subsidiary protection for persons who cannot be qualified as refugees or conditional refugees, but who will be sentenced to death or will face the death penalty or inhumane or degrading treatment or punishment or torture if they return to the country of origin, therefore need international protection. International protection is distinct from temporary protection under Turkish law. Temporary protection was provided under one single article in the law on the foreigners and international protection under Article 91. However, because of the mass influx of Syrian nationals starting from 2011, the Turkish legislature had adopted an important number of secondary secondary instruments to supplement this only provision of the law on foreigners and international protection. According to these provisions of temporary protection regulation and of the law of foreigners, the persons who are forced to leave their country and cannot return to the country that they have left, who seeks immediate and temporary protection and have arrived at or crossed the borders of Turkey as a part of a mass influx or individually in a mass influx situation, and thus their request for international protection cannot be taken under individual assessment, are granted temporary protection under Turkish law. Therefore, the most important differences between international protection and of temporary protection is that under temporary protection, the persons arrive to Turkey as a part of mass influx, and second, the protection they see is immediate and temporary. The citizens of Syria are granted temporary protection under the temporary protection regulation if they have come to Turkey as a result of the events that have taken place in Syria since 28th of April 2011. However, unlike the Temporary Protection EU Temporary Protection Directive, the Temporary Protection Regulation does not provide for the duration of temporary protection. Therefore, it is still unknown how temporary is this protection in Turkey. Speaking about legal rights of the Syrian nationals, of course, this is a very large subject which we cannot handle in less than now 15 minutes, but I will try to briefly explain. The Turkish constitution provides for equality before the law for everyone, meaning for citizens as well as for foreigners under Article 10. The main provision of the Turkish law on foreigners is Article 16 of the Turkish Constitution, which provides that the fundamental rights and freedoms of foreigners may only be restricted by law, meaning the act of an act of Turkish Parliament, compatible with international law. The rights of Syrian nationals, including the right of stay, to health, to education, to access to labor market, family reunification or representation by a lawyer, social assistance and interpretation, are provided under the Temporary Protection Regulation. Their right of access to labor market was further provided by the regulation on work permits for foreigners under temporary protection. Therefore, where these are specific rules applicable for Syrian nationals under temporary protection, but where no specific provision exists, then they are also subject to the general provisions applicable to the foreigners in Turkey. I will be speaking about the right to stay, the right to health and education, right to the labor market and social assistance, which are all provided mainly in the temporary protection regulation. But I will also want to make some remarks about the acquisition of immovable property in Turkey, as well as acquisition of Turkish citizenship by the Syrian nationals, a topic which we discuss nearly every day in Turkey. The first is the right to stay. The persons under temporary protection are given the right to stay under the temporary protection regulation. It is clear from the regulation that the document which is given to them, the temporary protection identification document, gives them the right to stay only. The right to stay is not equal to a right of residence in legal terms, and it is provided under the regulation that this right of stay is not, or this document does not give them is not equal to the residence permit or a document which substitutes resident permit. It does not give them the right to apply for long-term residence in Turkey, and the duration of this document is not considered in calculating the total term of residence in Turkey. According to law, temporary protection beneficiaries may stay in the temporary accommodation centers or may be given the right to reside in provinces if their situation is not contrary to public order, public security, or public health. As a matter of fact, today there exist seven shelter centers in 5 provinces, Turkish provinces. However, most of the Syrian nationals are or live outside the shelters. The number of Syrians living outside the shelters is 3.6 million, which is far more than the persons living in shelters. This is as of March 2022. The right of health and the right of education are provided under the temporary protection regulation for the Syrian nationals. As far as right of the health services is concerned, the health services provided for them are mainly primary and emergency health services, which may be subject to a patient contribution fee. They cannot approach private health institutions unless an emergency case occurs. The necessary vaccinations for children as well as for the risk of infectious diseases are conducted by by the health institutions. The education activities are conducted inside and outside temporary accommodation centers. They receive primary and secondary education activities, and other than these, preschool education, language education, vocational courses, skills trainings, and hobby courses are also conducted. And the rules and procedures for the graduate and undergraduate studies at the universities is determined by the Presidency of Council of Higher Education in Turkey. As of today, there are 177 migrant health centers funded by the EU through its facility for refugees in Turkey. Syrian nationals benefit from free of charge healthcare provided both in the migrant health centers and in Turkish hospitals. According to the Turkey 2021 report of the European Commission, Turkey made sustained significant efforts to provide support for refugees and ensure wider access to healthcare and schooling. Although most of the children receive formal education, as of 2020, there are still around 400,000 school-age refugee children which are outside school and therefore does not have the opportunity to have an access to education. Access to labor market, the first thing is that as all foreigners in Turkey, Syrian nationals also are required to apply for a work permit. And in Turkish law on foreigners, some professions are confined to Turkish nationals. So this is an exception for all foreigners. This is also an exception for Syrian nationals. They had to apply for a work permit following 6 months from obtaining the temporary protection status. There is an exemption for seasonal agriculture of livestock works that they don't have to obtain a work permit. quota may be set for the employment of foreigners under temporary protection based on the needs of the sectors and province. In fact, in principle, the number of temporary protection beneficiaries active in a specific workplace may not exceed 10% of the Turkish nationals working in the same workplace. Again, there is a limitation as to all foreigners in Turkey, in certain cases, a pre-authorization requirement in the employment of some professions, such as doctors, nurses, opticians, midwives, as well as professionals of education. This pre-authorization requirement also applies for the Syrian nationals under temporary protection. There are specific provisions as to Syrian nationals who are health professionals and who would like to provide services in accommodation centers and migrant health centers. They are exempted from certain requirements. So there is an easier way for them to work for in these centers. The persons under temporary protection may be allowed access to social assistance if they are in need. So there is nothing like all the Syrian nationals receive social assistance without any requirements. One important issue has been acquisition of immovable property by the Syrian nationals. This is an important issue for integration of these persons in Turkey. I think we should start strictly about the integration of these persons, and acquisition of immovable property is an important aspect for that. In Turkish law, the land registry law under Article 35 regulates the acquisition of immovable property by natural persons. According to this provision, the first requirement is that the citizens of countries who are eligible for acquisition of immovable property in Turkey are determined by the President of Turkey. And the citizens of countries who are determined as such can purchase maximum 30 hectares in total, and in a district up to 10% of the total privately owned area of the said district. Historically, the Syrian nationals cannot acquire immovable property in Turkey due to historical conflicts between Turkey and Syria. Other than that, Syrian nationals are not provided in the list of countries which citizens of which are eligible for acquisition of such property in Turkey. Therefore, they cannot acquire such property as natural persons in Turkey. Lastly, one very important question about Syrian nationals has been whether they can acquire Turkish citizenship. They can acquire Turkish citizenship as a group. They can, or they, what would be the procedure for them to acquire Turkish citizenship? Before moving to these questions, a report of 2017, based on a survey of 50 Syrian nationals living in Izmir, shows that 88% of Syrian nationals would like to acquire Turkish nationality. As of 2017, their reasons included to have a work permit, to have an access to education and health services, to have equal treatment with Turkish citizens, to have the right of movement, to have economic rights such as the acquisition of immovable property, and to have the will to have a sense of belonging to a country. As it is seen, the results include certain rights such as the right to have a work permit or access to education and health, which are already provided for Syrian nationals under temporary protection regime, which means that they may not be enjoying these rights in practice, although they are clearly provided in law. However, we have to underline that the survey was made in 2017, and I hope that the situation have gone to a better direction since 2017. As to their acquisition of Turkish citizenship, the first important thing that we have to underline that under Turkish citizenship law today, it is not possible to accept a group of persons as Turkish citizens, meaning that they are subject to individual assessments by the Turkish authorities. Today, the Article 66 of the Turkish Constitution, as well as Turkish Citizenship Law of 2009, provide for the legal basis of acquiring Turkish citizenship. The Temporary Protection Regulation only provides for two provisions on Turkish citizenship. The first one is that under the regulation, it is stated that Turkish citizenship terminates temporary protection on individual basis. And secondly, it is stated that the temporary protection identification document does not entitle its holder to apply for Turkish citizenship, and its duration is not considered in calculating the total term of residence permit durations. This means that under Turkish citizenship law, as I will be summarizing in a minute, the Syrian nationals can acquire Turkish citizenship when they satisfy the conditions provided under this law, unless the law requires a certain period of residence in Turkey. As of the end of 2021, according to the data provided by Turkish Ministry of Interior, 193,000 Syrian nationals acquired Turkish citizenship. However, unfortunately, we do not have the information on the ground of Turkish citizenship. Therefore, the legal basis is not clearly known by the public. Before how they can become Turkish citizens, I answered the question which procedures do not apply to Syrian nationals. The first is ordinary procedure for naturalization, because it requires an uninterrupted legal residence of 5 years in Turkey, as Syrian nationals cannot have legal residence in Turkey because of the clear provisions of the temporary protection regulation. They cannot benefit from this provision at all. There is also the exceptional procedure for naturalization, which is an easier way to acquire Turkish nationality for different groups of persons. The first group is the foreigners who become or who acquire Turkish nationality due to their investments in Turkey. This is a very debatable issue lately in Turkish academia. The Syrian nationals cannot benefit from this provision either, because these persons should hold a short-term residence permit at the first place. Therefore, since the Syrian nationals cannot have residence permit in Turkey, but rather a right to stay, they cannot apply to Turkish citizenship based on this provision. Likewise, the Turkish citizenship law also provides for acquisition of Turkish citizenship by turquoise card holders, like the blue card in the European Union. However, it is clear from the international workforce law that the persons under temporary protection cannot obtain turquoise card at all. So they cannot apply exceptional procedure on this basis. And thirdly, normally migrants may apply exceptional procedure for naturalization. However, the term migrant is defined in Turkish law specifically under the Turkish Settlement Act as persons having Turkish origin and culture and who either individually or as a group have come to Turkey with the purpose of settlement. Therefore, although it may be thought that some temporary protection beneficiaries may have Turkish origin and culture, since they do not come to Turkey with the purpose of settlement, they cannot be accepted as migrants. Thus, they cannot apply for Turkish citizenship under this provision either. Of course, it is possible to acquire Turkish citizenship by birth. This also applies to Syrian nationals as well. However, in very limited situations, more probable would be that they will benefit from naturalization from exceptional procedure in some cases. The exceptional procedure will also applies to foreigners who bring industrial facilities to Turkey or who bring outstanding services in areas of science, technology, economy, social sciences, sports, culture, or art. Therefore, if there are any Syrian nationals satisfying this requirement, it is possible for them to be subject to this procedure to acquire Turkish nationality. There is also one group where the Act provides that the group of foreigners who are deemed necessary to acquire Turkish citizenship may acquire Turkish citizenship by the decision of the Turkish president. This, of course, gives a very wide discretion to the Turkish president to decide on which groups are deemed necessary to acquire Turkish citizenship. It is thought, at least in the Turkish academia, that most of the Syrian nationals, as well as refugees, acquire Turkish citizenship based on this provision in the Turkish citizenship law. It is also possible to acquire Turkish citizenship for the Syrian nationals by way of marriage, but it is not an automatic procedure. It requires a 3 years real marriage by a Turkish citizen, or sometimes by way of adoption for the minors, or by exercising the right of choice. I think this this ends my presentation, but I would be very happy to answer any questions if there are to me.